Who owns your creations? Ever poured hours into creating a script, image, or song with AI only to wonder if it's truly yours? Or worse, could someone else claim it? You're not alone. Founders and creators are racing to use AI to streamline work, scale businesses, but the legal world hasn't caught up yet. The rules around AI and who owns AI generated content are murky, and real-world lawsuits are exposing the risks. In this video, I'll break down what you need to know about intellectual property when using AI and practical steps we're using to potentially protect ourselves. So let's figure out how to use AI confidently without potentially stepping over any legal landmines. If we haven't met yet, I'm Johnny Nell. I've spent years building businesses across multiple countries and industries, partnering with founders and CEOs just like you to tackle the challenges of starting, building, and growing businesses online. But I'm not here to talk about me. Right now, AI might feel like it's adding stress and complexity, pulling you away from what matters most. On this channel, I share a different way with AI, a path to sustainable growth, modern leadership, and creating teams and systems that work effectively and efficiently. In my experience, the future isn't about having the biggest teams, it's about staying agile, lean, and adaptable. Before we get into the big question of who owns AI-generated content, here's a quick disclaimer. The information in this video is provided for general, informational, and educational purposes only. It is not legal advice and should not be relied upon as such. While I draw from personal experience as a founder and entrepreneur, I'm not a licensed attorney, and the insights shared here do not create an attorney-client relationship. Laws around AI-generated content and intellectual property are rapidly evolving and vary by country. The examples and references included are based on currently available information as of the date of the publication and may not reflect future changes in the legal landscape. Before making any decisions related to AI, IP, or copyright protection, especially in business or commercial settings, you should consult with a qualified intellectual property attorney in your jurisdiction. This will help you to ensure that you're taking the right steps based on your unique situation and local laws. Mention of any third-party tools, platforms, or legal cases is for informational purposes only and does not constitute endorsement or legal interpretation. So just imagine this. To write a killer script for your next YouTube video. It's perfect, it's engaging, on brand, and ready to go. You post it, and it starts ranking up views, potentially get monetized, or you're already monetized and you're monetizing from the video. Then out of nowhere, you get hit with a legal notice claiming the script infringes on someone else's copyright. Or maybe you try to copyright it yourself, only to find out it's not even eligible. This is the current reality of AI and IP today. When you use AI to create content with scripts, images, videos, music, etc., the question of ownership isn't straightforward. And here's why. Traditional copyright laws built for human creations, not machines. So let's break it down. The legal landscape is currently a work in progress. Copyright protects original works like books, songs, or artwork. But for work to be copyrighted, most countries require a human author. Since AI isn't human, content it generates on its own might not qualify for protection. However, if you as a founder provide significant creative input like detailed prompts, edits, or combining AI outputs with your own work and voice, you might be able to claim ownership. The catch? Significant isn't clearly defined and it varies by country. Here's a quick look at how different places handle this. In the US, works must have human authorship. Purely AI-generated content isn't copyrightable, but human-guided works might be. United Kingdom allows copyright for computer-generated works with ownership going to the person who arranged the AI's creation. In China, they've suggested AI-generated works can be copyrighted if they are an intellectual achievement, but it's case by case. The European Union requires originality and human intellectual effort. AI works are a grey area with national laws differing. This patchwork of rules means your ownership depends on where you're based and how you use AI. But there's another area here that is important to take into consideration, and that is the data used to train the AI. AI doesn't create in a vacuum. It's trained on mass data sets. Think of songs, books, images, If those datasets include copyrighted material without permission, the AI's output could infringe on those rights. This is at the heart of recent lawsuits against AI music platforms like Suno and UDO. Here's some quick background on the case. In June 2024, major record labels like Universal Music Group and Sony Entertainment, backed by the Recording Industry Association of America, Suno and UDO for copyright infringement. They claim these platforms trained their AI on copyrighted songs, allowing users to generate music that mimics artists like Chuck Berry or Mariah Carey, and the labels are seeking up to $150,000 per infringed work, which could total hundreds of millions. Suno and UDO argue their use of copyrighted material is fair use, but the labels call it shameless copywriting. These cases are still going, but they show the risks for both AI developers and users. If you create content with AI trained on data, you could face legal challenges, even if you didn't know the training data was copyrighted. So who owns the script, the image, the video, or the song you're making with AI? What we have to realize, there's three potential possibilities. So the first one is you as the founder. If you treat AI like a tool, say a paintbrush or a word processor, you might argue you own the output. The more creative input you provide, example, detailed prompts, heavy editing in post, the stronger your claim. Courts in some places like UK might back you up if you arranged the creation. Secondly, the AI developer. Some argue the company behind the AI model could claim rights since they built the system. However, this is complicated by training data issues. If the developer used copyrighted material, their claim could be shaky. And thirdly, if the content is purely AI generated with minimal human input, it might not be copyrightable at all. This means anyone could use it, leaving you without legal protection. As a founder, entrepreneur, creator, or business owner, this uncertainty is a problem. You want to use AI to save time and potentially scale your business, but you don't want to lose control of your creations or face lawsuits. Say you use AI to create a promotional video script for your startup. You post it on YouTube and it goes viral. Then you get a letter claiming the script infringes on a copyright work used in the AI's training data. Or maybe you try to sell the script only to find out that it's not protected because it's too AI generated. Here's the risks you're currently facing. Firstly, the challenge you would face if your video was uploaded to YouTube. YouTube strikes. So if you get 3 strikes specifically pertaining that copyright infringement, you could lose your channel. And if your channel is monetized, if you're earning from it, and you've got your entire library stored on YouTube, that's quite catastrophic. So by the way, guys, go and download all your information so long to hope that if something like that ever were to happen for whatever reason, you don't lose your content. Secondly, copyright infringement liability. If the AI's training data included copyright material, your content could be seen as a derivative from the work, making you liable for damages. Thirdly, no copyright protection. Without human authorship, your content might not be copyrightable, meaning competitors could use it freely. Fourth, platform terms. Many AI tools have terms of service that limit your ownership. Always read the fine print. These risks aren't just theoretical. The Suno and UDO lawsuits show that industries are fighting back against AI-generated content and users could get caught in the crossfire. So how to protect yourself? You don't have to avoid AI altogether. It's a powerful tool for founders, creators, entrepreneurs, but you need to be smart about it. Here are some practical steps to potentially minimize future risks. Add your creative input. The more you shape the AI's output through prompts, edits, combining it with your own work, the stronger your ownership claim. Think of AI as a starting point, not the final product. Then check the terms of service before using any AI tool. Read its terms. Do they claim the rights to your content? Do they guarantee the training data is clean? Tools like those offer licensed data sets with safer bets, right? And then you need to stay informed. Legal battles like the case with Suno could change the rules completely. Follow industry news, know about your rights, and consult with a lawyer. If you're using AI for high-stakes projects, talk to an IP lawyer to understand your legal laws and risks. So why does this matter for your business? As a founder, you're focused on growth, efficiency, and stepping ahead. AI can help you create content faster, cut costs, and scale without massive teams. But if you don't understand the IP risks, you could face legal battles, lost assets, or wasted time. By knowing the rules or lack thereof, you can make informed decisions and use AI to build lean, adaptable infrastructures for your business. And here's the mindset around it. See it as a mental model. Think of AI generated content on a spectrum. You can break it down into the level of human input and the likelihood of ownership. For example, look at something minimal, like a prompt. That's quite low. Typing something to write a script into ChatGPT, not that high, right? Something moderate could be like detailed prompts or light edits. Crafting specific prompts and tweaking output, it's not bad. And then high, it could be something like heavy editing, combining it with work, using AI as a draft, and then rewriting it extensively. The more you move towards the high input, the better your chances of owning the content. Use this model to guide your process. And then we can look also at the bigger picture, looking at the innovation versus the rights for, in this case, artists. The debate over AI IP isn't just about ownership. It's about balancing innovation with fairness. AI can democratize creativity, letting small businesses compete with bigger players. But artists and creators worry that AI trained on their work without permission undermines their livelihood. The Suno and UDO lawsuits are a flashpoint in this fight, with record labels arguing that AI companies are stealing artists' life work. And what does it mean for you as a founder? As a founder, you're caught in the middle. You want to use AI to grow, but you also want to do right by creators. This tension is why the law needs to evolve and why your voice matters. The future of AI IP is unwritten, and it's up to us, founders, creators, and leaders, to shape it. Do you think AI-generated content should be copyrighted? Should users be responsible for what the AI tools produce? How do you balance using AI with respecting artists' rights? Drop your thoughts down in the comments. I would love to know a little bit more about what you think, and let's map out what this could look like together. And if you believe this information is beneficial for you, give me a thumbs up and subscribe if you feel called to it.